At Symphorien-Saavedra Law, we believe that every immigration story is unique. Immigration law is more than just a service, it's our sole and passionate focus. With over 4 decades of combined experience, our dedicated team is here to walk beside you, helping individuals, families, workers, and investors navigate every step of their U.S. journey. We take on small cases, large cases, and everything in between, always adapting with flexibility to meet your needs. Our expertise spans work and investment visas, family immigration, humanitarian visas, asylum and deportation defense, citizenship and nationality, and federal court litigation. At Symphorien-Saavedra Law, we love what we do because for us, immigration isn't just about paperwork, it's about people, dreams, and new beginnings. And we firmly believe your future has no boundaries. Let us guide you toward achieving your goals in the United States.
All right, good afternoon, everyone. Thank you for joining us. My name is Frank Symphorien. I'm a board-certified immigration expert, and I am the founding partner of Symphorien-Saavedra Law. And I have the privilege of having my partner and a close friend, Melissa Trevino, who is outstanding in her field as well. Melissa Trevino has been I've been practicing law for over 18 years at this point, and I'm one of the few board-certified experts in the field. And then my partner, Melissa, has been practicing with me at least for 6 years now, has it been, Mel?
Yeah, it's
and she's just amazing. She was formerly a paralegal, so she worked, has that intimate, that's how she's so great, because she was able to pick up the intricacies of how to handle immigration law for over 10 years before that, right?
correct.
So total, I think we're over 16 years of immigration practice at this point. Excellent. So thank you for joining us. This is, I guess, our second of our ongoing series on updates and discussions regarding immigration topics for our clients and people in the community. We want to try to educate people, keep them informed of what's going on in the immigration world, and we're happy to provide that information. So I think we have a list of questions that we can kind of get going here with. Our first question, I guess, Mel, you can.
Yeah, I'll go ahead and ask here, what 2026 immigration policy changes have caused the most confusion among your clients? And I know, from the very beginning, there's so much, right? Litigation is ongoing. Changes are being done overnight. Everything is causing confusion. Decisions are being made and they're just coming out on a daily basis. So everything is causing everyone confusion at this point.
Yeah, the Friday weekend surprise. Every Friday, immigration attorneys, leadership throughout the country, essentially, we all expect every Friday for our weekend to be ruined by some new policy change that, is going to have us frustrated. But, I think there's a lot, but we can kind of talk about the most recent ones, right? I think one of I would say the adjustment of status memo, right? That caused a lot of confusion, even though the government tried to walk it back a couple of days later, even though they didn't actually walk back the policy pronouncement. But just to give you all a quick update on that, what that is, maybe about 3 weeks ago, Department of Homeland Security put out a policy memo and also a press release informing people that essentially they were they were starting to enforce the rules, even though that's never been the rule. They created a new rule, and they were going to require anybody who overstayed their visa to depart the United States and request consular processing from abroad, absent extraordinary circumstances. And they essentially kind of mischaracterized the history of the adjustment of status process to suggest that Congress never intended people to stay in the United States and change their status from whatever status they had to residency. And then they also started putting out a bunch of details and questions that were imposing requirements that officers at interviews start asking people, why did they not go back? Why did they overstay their visa? And what prevents them from departing the United States and coming back and following the proper rules? There wasn't really any nuance to this. There wasn't any explanation as to, some of those processes where people enter for the purposes of seeking adjustment of status, like fiancés who come in with 90 days to get married and then file the adjustment. This was a process that was authorized by Congress. They also don't explain how it is that Congress created the path for and eliminated limitations or bars for seeking residency for spouses of U.S. citizens when, a lot of people have overstayed their visas for whatever circumstances. But Congress created a path for them, and it didn't say anywhere in the congressional statute that persons had to show extraordinary circumstances. So, but what the memo does is it sort of back channels, it creates a back door by using what is in the statute, which is discretion. The discretion forever has been understood as a balancing of factors in regards to consideration of any immigrant who's seeking permanent residency. And you're supposed to balance any negative factors versus positive factors. Well, forever, the presumption had been that if the only negative factor was that you overstayed your visa, or you were married to a U.S. citizen, well, the presumption was that that single issue of just overstaying your visa was not enough to bar your adjustment, that there was multiple cases that established this presumption. Well, without saying they're overriding the case law and the precedents that require this, this new memo essentially is trying to say that there is no such presumption and that everybody's supposed to depart absent extraordinary circumstances. I think that's probably the most the one most recent that's caused the most havoc, right, Mel? I think
a lot of people started getting nervous, saying, "No, I'm not eligible anymore. I need to depart," and that's not necessarily the case. Obviously, they're just trying.
It's a trap, right? Talk about how it's a trap, Mel, because the overall majority, if you leave, you're going to be stuck abroad because you're going to have an unlawful presence bar that says you can't come back for 10 years. So, I mean, it's one of those things where I just met with somebody who filed for adjustment of status on their own. And I mean, it used to be the case that you could trust the government to act in good faith, immigration officers, and to give you an opportunity to correct any, minor, errors in your application and so forth. But the problem these days is that if you file for adjustment of status on your own and you make a mistake, you're going to be sent to immigration court. That's a clear thing that's happening now. You're going to lose your money, and you may get deported. So it's just I don't understand for the life of me. I used to say, hey, if you're smart and you're educated and you have the time, anybody could do it on their own, because you could look up the instructions, take your time, read everything, try to educate yourself. And if you didn't have a criminal history or any significant complications, you could do it on your own. But in this environment where they're even arresting people at immigration interviews with babies in their hands, I just don't understand for the life of me how anybody files on their own without legal counsel.
Of course. And again, with all the policies changing overnight, I mean, not everyone is following that. So it's important to, have that legal counsel that is informed of the policies, is informed of all the changes, to obviously better prepare you for the interview and be there, for that. So definitely, I agree with that. There's just a lot of things going on, and it's just best to have that legal counsel next to you.
Right. There's also the detention policies, right? One of the other ones that, has caused a lot of confusion is, for a long time, fortunately in the 11th Circuit, there was recent decision that allowed immigration judges and attorneys to request bond before immigration courts. But still, for probably about 7 months, we had a constant confusion where, if you were detained and you had entered unlawfully, there was no way to seek a bond while you were in immigration court. And everyone in that circumstance had to request usually essentially federal court intervention. We had filed the most lawsuits probably, in 18 years of practice, Mel. I think this year I've filed probably 50% of the number of lawsuits that I've filed over the course of 18 years.
Yeah.
So I don't know. Can you think of any other policy changes that have been impactful?
There's so many, there's just so many shifting things, right? I mean, fees, USCIS fees are changing, the process even for payments, the annual asylum fees, that's not recent, but that is something that's completely new, and it affected a large group of applicants. it's just a lot of just things are changing on a daily basis. I mean, every day there's something different with a policy.
Yeah, I think the adjustment memo is the one that's has affected obviously us the most.
A lot.
There's obviously the TPS back and forth for Venezuelans, and unfortunately yesterday Supreme Court cleared the path, right, for the government to terminate TPS for just about every country essentially. I mean, they're saying that the court has no jurisdiction to review any determination of the executive branch in regards to temporary protected status. So unfortunately, those people that had a little sliver of hope that TPS would be saved for Venezuelans or for Haitians or Syrians, that is no longer the case. That's gone out the window. There's also all these military judges that are being hired to work in the immigration courts. There's also the Sixth Circuit decision. I don't know if you remember, heard of this, Mel. The Sixth Circuit decision essentially allowing the government to continue its efforts to expand expedited removal for anybody that entered unlawfully, who has less than 2 years of physical presence. So it used to be that if you'd entered the United States and you could establish that you had been here for at least 14 days, then the government could not use any expedited mechanism to remove you. And the expedited removal provision is a really controversial provision because it's immigration, customs, and border protection officers acting as immigration agents, but also as judges. And they can issue you a removal order at the border without you ever seeing an immigration judge. I mean, they're the ones that charge, like the most bizarre thing. They charge you with having entered unlawfully, and then they also order you removed on their own without having the intervention or recourse of seeing any immigration judges. The only exemption is if you claim asylum, but again, they are the ones that make that determination as to whether you made a proper claim. So who knows how many people have claimed asylum but haven't been referred to immigration judges. So essentially, it's allowing the government to expand that to anybody who's been physically present for 2 years. I think that's that's back in play, and I think the expanded use of this is one of the reasons why recently you were hearing maybe about 3 or 6 months ago of detentions at immigration courts at where people were being almost tricked, right? It felt like they were being tricked into coming to court, and then at court they were asking the judges to dismiss the proceedings, the removal proceedings, so that they could use this expedited provision where the judge is not involved and the customs officials is the one that's ordering the removal. The other favorable thing that just happened over the last week or so was that the federal judge did enjoin the practice of detaining people at immigration court. So that's one positive development. I don't believe it reaches into the surrounding areas, right? So I don't think it bars customs and border protection immigration agents from, waiting for you outside of the immigration courthouse, et cetera. I got to double check on the decision as to, I'm sure there's some perimeter, right? There's some distance requirements to how far they must be from the immigration courts. But for now, at least we know that they can't continue to do them inside of the immigration courts, which I think is a great development. So there's a lot, but I do think the adjustment memo is the one that's the biggest one, as well as the detention. I think we have hopefully, I don't want to take up all the time in one question. We have another question on the way.
No worries. So the other one is, have you noticed any changes in how USCIS is reviewing petitions this year? And again, this kind of was discussed a little bit more even with the adjustment memo, where they're being a little bit more particular in the discretion. They are vetting more, checking more backgrounds, or they're just taking more time to actually make a decision on cases. They're looking at the documents a little bit more detailed, so that they're just looking overall at all of the applications, just a little bit more strict. So that's something that obviously USCIS is doing definitely with petitions this year. And that kind of just goes into what we just talked about, all of the policy changes, where they're just paying more attention to certain either types of cases or even where the applicant is from. Some applications are just pending until further background or further checking on, vetting their cases. So that is something that obviously has continued to develop. However, they're still, receiving and accepting cases. So it's not something that you want to stop. You just want to be able to get legal counsel to review the case, make sure it's fully prepared and fully prepare you as a client for any interviews coming up. So that's something that changes from USCIS.
Yeah, I agree. I think that everything is sort of evident from just the change in the goal or the vision of the agency, right? Where it used to be a benefits processing for customers. I think the vision and the pledge of the agency was changed to a vetting agency that is rooting out fraud, and they're sort of presuming that everybody's committing fraud. And I think that the mantra that I'm hearing from officers and everyone is that it's an environment and a climate of extreme vetting, right? So if you go forward with immigration, you need to be prepared for them to scrutinize every aspect of your case. I think we have another question on the way.
Which group of immigrants are most affected by the 2026 changes so far?
I don't know. I tend to think it's every single immigrant. I mean, I can't imagine any. I mean, there's a misconception out in the community that this is only applying to immigrants who enter illegally or who didn't wait the line. And we have the benefit of practicing in all aspects of immigration law, whether it's business immigration, labor certifications, et cetera, as well as humanitarian immigration. And in my opinion, I mean, we're seeing it everywhere. I mean, we're seeing the lowest approval rates for national interest waivers that we've ever seen, right? I think since the standard was changed under Danisar, we've seen some really low approval rates for old petitions, which we're going to try to discuss a little bit more later, extraordinability petitions, and all these changes that we discussed as far as removal proceedings have been, significant. Anything you can think of?
Yeah, I mean, not only, like you said, everyone that's here, that's, asylum seekers or TPS holders, but they're also just family petitions for consular processing. If you've petitioned for a parent that is living in their home country, but that parent lives in one of the travel ban countries, they're not being allowed to travel into the US, even having a petition approved, going through the process the legal way, but they are not issuing these immigrant visas. So a lot of people are being affected all over worldwide. I mean, it's not just for individuals that are here in the US.
Really sad. And I guess, in that, I will say, our heart goes out to the people of Venezuela with that terrible tragedy. And, luckily, most of my family hasn't been impacted. And I do have some friends that have been impacted in Caracas, but we do have some clients, that's one of those sad things. I'm going to try to figure out how to make time for one of our clients in particular, whose father is there, is an 80, almost 90-year-old man. And he's stuck there, and he has a U.S. citizen son with a petition pending. But because of the extreme vetting and the delays in the non-immigrant visas, the humanitarian visas, and all these options, he's struggling to figure out a way, and we're going to, try to work with him to figure out how to get his father back. But his father was in Caracas, in La Guaira, in the area that was close to Caracas, one of the principal areas that were affected. And, fortunately, he's okay. He's alive. But his son is, distraught here in America without a quick path, even in this humanitarian situation, to bring him forward. And it's one of those sad things too, because this is a situation where the country's unstable, and in past administrations would have considered immediately granting temporary protected status. We did it for Haiti back in 2010 when they underwent this type of calamity. And so, I wish maybe there's some sliver of hope that this government will grant temporary protected status to Venezuela. I don't see it happening, but we'll do our best to help the people that we can in Venezuela, and our prayers are with everyone there that's affected. We have another question.
I think the next ones do go into a little bit of the O and the EB1 categories. Here is, what's the difference between an O1 and an EB1?
Yeah, so this is a good question. There's essentially very little difference because it's the criteria is very similar. It's a path that allows people who have extraordinary talents and who are able to transition from a temporary non-immigrant visa, which is usually 3 years, with the O1 visa, and they can transition into permanent residency with seeking an EB1. One of the differences you could argue, so that is the difference, right? So the O1 is a temporary visa that allows you a limited period of time of 3 years, and EB1 is a permanent immigrant visa that allows you to seek permanent residency and remain living here indefinitely, right? Another difference is that the O1 in general requires a sponsor or a sponsoring agent. The EB1 does not, and you can actually do a self-petition for the EB1 category. There's also arguably some differences in the regulations. There's a lot of strong arguments that the O1 criteria is met when you meet one of the 8 paths. So the O1 and the EB1 both share an analytical framework where you have to establish that, you're at the very top of the field of endeavor, and you're among the very few in the field who are truly extraordinary. At least the O1A, right? Because there's other 2 types of there's a O1B, which is people in the areas of the arts, that allows people in that specific area, or in the pictures, motion pictures and television field, and it lessens the standard where the person doesn't actually have to be extraordinary, but they have to just show a level of distinction, right? And so for O1Bs, there's probably a much bigger difference from EB1A because the standard is much lower. You don't have to be extraordinary. You just have to have a level of distinction, and the criteria is different. But if we're talking about the O1A and the EB1A, the analytical framework is essentially the same. You have to, have you could have a single lifetime achievement award like a Nobel Prize, or such as an Olympic medal, right? And you would immediately qualify for an O1 or an EB1A. For the O1, you do still have to have a sponsor or an agent. But if you have that one lifetime achievement, you automatically qualify because you can establish that you meet that high level of ability. You do also have to show for both that you have sustained that level of achievement. So it can't be that you won an Olympic medal, 10 years ago or 15 years ago, and you're coming to retire to the United States, because for both, primarily for the EB1 in specific, you have to establish that there's a benefit to the United States. There's some benefit to the United States in you coming here. They both require sustained achievement, so you have to show that you've maintained that level of achievement. And again, the EB1 requires also that you benefit. So if you're retiring, there's probably not a prospective benefit to the United States, which is the language that's used, prospective benefit. But the O1, you have a difference in that there's a lot of strong arguments that the regulatory criteria, the way that it was established is that it's essentially once you meet 3, either if you establish the 1 lifetime achievement, or you have to meet 3 out of 8 or 10 criteria. So such as, judging the work of others, published materials about you, patents that you have completed, that, published materials where you have a lot of citations and you're cited as an authority of the field, materials that talk about you and your achievements in the field, sitting in a panel and judging the work of others, I think I talked about. Mm-hmm. So the criteria, the analytical framework is essentially the same, but there's a stronger argument to be made that in the O1, at least from the regulatory publishing process, that in the O1, once you meet the 3 criteria, then the O1 petition should be approved. There's not supposed to be a second step analysis as to whether subjectively you are actually at the top of the field. And in the EB1 area, there's this case called, oh my God, I'm drawing a blank, but there's a case that essentially created an analytical framework where the government's supposed to take 2 steps. First, they're supposed to look at whether you meet the 3 criteria, or the 1 lifetime achievement award. Do you have the numerical analysis as to whether you meet each of the elements, whether you have the published materials about you, the judging the work of others, and you have to have 3 of those, or a one-time lifetime achievement award like an Olympic medal or Nobel Prize. But then what the government, Kasarian, that's the case. The case is called Kasarian. And the Caesarian standard, which the immigration agency adopted, it's a district court case where somebody sued. The Caesarian case established a test where the government has to go into a second step. Once they meet the numerical analysis in the first phase, then they have to go into the second phase where they do a qualitative analysis, essentially, and they consider whether subjectively the person not only has they met the quantitative numbers of each of their criteria, but also are they truly at the very top of the field, right? And I always tell clients that this is sort of like a subjective, am I impressed by this person, right? And are you impressed, or are other people that are authorities in your field impressed by your achievements? And that's essentially what I'll tell our clients. So those are some of the key differences. I don't know if there's a follow-up question.
Yeah, I have. What is the most common mistake you see highly qualified people make when applying for an O1 or an EB1 visa? I think for one of the mistakes I think a lot of people do when they are applying, especially when they're doing it on their own, is the requirements sometimes have two parts to them. For example, if you're employed, one of the requirements could be to show evidence that you're employed in a critical or essential capacity for an organization, and that organization has a distinguished reputation. A lot of people just meet one of the two, and they just, that's a mistake, that when they provide the documentation, or they only provide that they show or that they were employed, but they don't show that the organization also has that distinguished reputation. So I think that is a common mistake when
all the criteria, right?
I'm sorry?
Yeah, for all the criteria, I think there's always like a full criteria have to be met, right? Yeah, I think one similar mistake is on the contributions, right? Original contributions. So, for example, you have a patent, right? Or you publish material that has an original idea, but there's a second component that it has to be of major significance in the field, and so that's a more challenging element, right? That it has to be of major significance in the field. Or, for example, where you talk about being a member of a group, a distinguished group, but then there's an element that says a professional group or whatever you can be a member of a group, but there's also a second component to it which requires outstanding achievement for membership, right? So you don't have to just be a member of a group, but the membership criteria has to require that. So you have to kind of look at the full elements of the test. Just to piggyback on what you're saying, one of the mistakes I would always say is that we get a lot of celebrities or a lot of people who are really good at what they do, and they just sort of think, oh, well, I'm the best, or I am, really great. And they think just the, fact that they're very famous or very distinguished in their field is enough, and there must be some way to qualify. Unfortunately, no. I mean, there's very rigid structure, rigid requirements. I tell people that, I have, a limited set of tools in my box, right, for immigration as an attorney. Unfortunately, I wish I had more. But in the old context, you've got these 8 boxes, and you've got to fit people into the boxes. And if you don't fit it, there's not like a catch-all category. I mean, there is a catch-all category for the EB1 and the O1, which just says comparable evidence. And people think it's a catch-all category, but it's not, because a lot of the government has interpreted is that in order to use that catch-all comparable evidence category criteria, you also have to establish that the other criteria are not adequate or don't fit in your field. Mm-hmm. And so that's also a challenge, because you have to disprove that the other criteria are not available to you. So I don't know if you have any other comment on any other mistake, but we do see a lot of mistakes, right?
Yeah. But I think is the most common one. It's just, they don't read, or you can't tell, you don't complete all of the requirements in that one element. And that's
right. There's also the sustain part of it, right? Like I have a lot of people who, I have a lot of material, I have a lot of published things, a lot of articles, a lot of this, but the articles are from 5 years ago or 10 years ago. And then, I explained, well, it has to be sustained. So we may have a challenge if it's not sustained. So I think we ran out of time, Mel. I think we're going to keep it for now, because I know you have a next appointment, and so do we.
I do.
So I would say thank you, everyone, for joining us. In these difficult immigration times, I do want to emphasize that it's critical important that you retain legal counsel to assist you in your immigration cases. And, I have the benefit of the privilege of working with two of the best immigration attorneys in town, Melissa Trevino and Evelyn Pavon. And so I encourage everyone who has any business immigration needs. Melissa's been specializing in the area of business immigration. She loves the E2 visas in particular, but labor search, we got to do a one on labor search, and she's been doing a lot of that lately. And so I encourage everyone to reach out to us. You can call our office, you can contact us. Melissa is amazing at what she does, and she would love to help. Any parting comments, Mel?
No, thank you so much for having me once again, and I look forward to all of the future meetings that we can inform the community.
Yeah, and if you still have questions, one of your questions weren't answered, we encourage you to follow us and to stay tuned for our next Facebook Live we'll be having. I think we're having that. It's the last Friday of the month, if I'm not mistaken. So you can look forward to that at the end of July, where we'll be discussing any recent developments as well as any particular visa that we can kind of go a little bit into more depth, right?
Perfect.
All right. Well, thank you everyone for joining us. Have a great afternoon. Have a great weekend. And we'll see you in the next few weeks.
Bye.